Yes.
Make resolution. Item number 4, 5, 6, 7, 8, 9. There will be difficulty of
Okay.
this. And I don't know whether if I am willing, well, not this matter. Another matter is there, which is item number 17. Kindly see 17.
17.
APSC again connected with that. That's what I thought.
No. He's the chairman.
Ah.
Was involved in his point.
Okay.
That's why I said. Secondly, one humble request. When we moved before the division bench earlier, Honorable Chief Justice Honorable A.D. Chaudhary was there. That somehow the Honorable Justice Chaudhary couldn't pick up the matter because again he was representing one council. So what I have seen that is assigned is by Chief Justice on administrative capacity on Division 2, DB2.
Hmm.
So I've seen that DB2
Correct.
and DB2. So I think this should go. A subject your lordship can take, I am ready. There is no problem.
No.
But this is an administrative order, so I thought that I will point out before the court.
We'll just say that it cannot be taken up by this bench.
Right. We will
We'll
go
go to the- No, 4 to 9.
4 to 9 and 17 also.
17, why?
There is a note there. We
Okay, before DB2. DB2.
that was only because the Justice Chaudhary could not take up.
I think mistake. It should have been here
Yes, sir.
because that is to run up is different.
Different.
Anyway, it doesn't matter.
I want to do this Mr. Rakesh Pal matter because there is a
Okay.
delay.
Okay, right. All right, item 4 to 9, huh? Mr. Deedas appears for the petitioner, Is this matter before some other bit, not before one of us, right? Right, Justice Buchanan, huh?
Can we listed
7, 8, 3.
Ah. 17 will see that it,
7?
has the paper book been made?
No,
So we can at least direct paper book to be made.
no problem. No problem.
At the time of hearing, you decide whether he should pick it up or not.
For me, there is absolutely no problem.
Okay, then,
For me, but paper book, as your lordship, without paper book also we can argue. IA. Paper book, there are about 23 numbers of.
I know he will pay. I think he will pay. Because we have a yes. Did it come?
No, it's no problem. For me, there is no problem. But only for these other matters.
Then we have a
Sir, adjourned. Can it be on Friday, madam? Because I have
room.
DB2 before DB2.
No, let it go before the chief. Let him decide.
We'll mention it before race.
Chief will decide. He will come next week.
No, already I think there is an administrative order. There is already an administrative order.
That it should be listed before the.
DB2, kindly see.
Item 4.
There is an administrative order.
But I think my name is specifically mentioned there.
But DB2 is, kindly see DB2 is assigned. Item number 4. No? Tick. That's what, that's.
Right. As as the administrative order of the Honorable Chief Justice states that the matter should be listed before division bench. A registry to list the matter before
On
the
Friday.
appropriate bench.
Friday can it? We're not inconvenient. It's not in.
Monday.
No, only. But if it is possible.
Why?
No, we just want, because this is getting late, that's why.
One day, what is the
No,
difference?
if it is can, if it is only a request.
Okay,
will be can.
Friday.
Deeply observed. There's 17 remain here, 17
17 will remain.
remaining.
17 will remain.
Yeah.
Next,
May I please your lordship? Also similar prep, item number 13.
what about it? Yes?
Item number 13, lordship.
Oh, you cannot take her. Okay, right. Leave this matter before some other day, not before one of us. Okay.
Lordship, Monday it keeps in list.
List the matter in the next week.
Deeply
Give a date. This is not the.
Item 27, madam. Yesterday I have circulated the agreement slip
Huh?
of difficulty today. Item 27.
Yes, yes. On the
Review.
prep made for adjournment by Mr. P. Bhardwaj, which is not objected to by the other side. List the matter after 2 weeks.
May it please the court, your lordship. Lordship, this is with regard to item 26. We had circulated an adjournment.
On the prayer made for adjournment by who?
B. Saikya on behalf of HK Das.
P.
your lordship.
Saiki on behalf of Mr. H.K. Das, the counsel for the appellate. List the matter after
2 weeks.
2 weeks.
Duly obliged, lordship.
May I please, madam? I beg to mention on IML for listing on Monday one.
Criminal.
My lord. Obliged.
May it please your lordship. Lordship, I beg to call for an affidavit in opposition. We have filed in item number 34 in the IA, your lordship. It is not there on the record. Beg to call for the same to be placed on the record.
Okay.
Much obliged.
Okay, good.
May I please the lordship, I beg to mention two criminal appeal from jail, my lord, to come up for hearing, my lord, on
On?
Tuesday, my lord, 9
Madam,
December.
for come up for hearing, that might be difficult. We can list it. I don't know if we'll reach. Because we have fixed a number of matters.
So come up for orders, my lord, on 9 December.
For what? Why orders? Now you want from hearing to orders.
Last time, my lord, in the month of April, my lord, to appeal, my lord, directed to prepare paper book.
Paper book has not been prepared.
Prepare, I have not received the
Yes,
paper
not
book,
yet.
my lord.
Okay, let it be listed.
Must have-
Listed.
Yeah.
No problem.
May it please your lordship, I am praying for listing of late appeal, my lord, immediately after vacation.
When?
After vacation, my lord, immediately.
Okay, give a date after.
Of late.
May it please, your lordship, I beg to mention item number 15, your lordship. A similar matter is pending before the Honorable Supreme Court, your lordship.
That.
Assam Andolan, your lord.
15. Yes. This matter, now this matter, the Supreme Court will decide what remains. It's got decided, six has been decided by the Supreme Court in your favor.
My
It
lord,
has upheld it.
I am from respondent number
15,
13.
your
my
lordship.
lord.
Item 15, no, item
Yes,
15.
15, your lordship.
Yeah, yes. Item 15, implementation of the Assam Accord. Now that is before the Supreme Court. What is this court going to decide? Yeah, PIL. So we'll close the matter.
Maybe
Ba-
next week, your lordship.
Huh?
Your lordship may close next week, your lordship.
No, not closing the next week. Why should I close it next week?
Your lordship, I'm just representing my senior, your lordship.
Who's the senior?
D. Chaudhary, your lordship.
Let him come, let him come.
He's out of station, your
If
lordship.
he's out of station, let him remain there. What can we do? When the matter is already being heard by the Supreme Court, the matter is there. Why should we keep this matter pending here? You cannot go to two courts on the same issue. That the Supreme Court is hearing the matter. You take instruction, you come at 2. What is your name?
S. Diffusa, your lordship.
S.
Diffusa.
Diffusa. You come at 2, you with the instructions from your senior. Whether he wants to withdraw this case pending the decision or we'll take a decision.
Obliged, your lordship.
May I please, your lordship? I beg to mention for the listing of criminal appeal.
Huh?
Criminal appeal.
You have to file.
No, for the listing, your lordship,
When?
next week.
What is the
Admission.
stage? What is the stage?
It's an admission, your lordship.
Admission.
Since the IA is pending, your lordship.
IAS pending. Written objection file?
Yes, your lordship.
Not.
Lordship, I beg to mention item 29 of today's list. Lordship, an additional affidavit has been filed by the petitioner. Lordship, I seek some time to file a reply, Lord.
You are challenging the validity of the, how?
For the want of legislative competence and colorable.
Under which para?
Lordship,
I know, which para? Which para of the sixth schedule?
Lordship, in para 20, therein the table has been given. In part 1 is the state of Assam, and then Meghalaya, and then Tripura, Mizoram. In this, our contention is that from the six schedule areas, tribal areas, the para 20, this Rabha Asang Autonomous Council has been conveniently excluded. So Lordship, in that view of the matter, certain privileges that are available to the six schedule areas are not given to this Rabha people. They are mainly Garo people, Lordship, residing in Gwalpara and the.
Yes, you want to find a reply.
Yes, Lordship, that is the instruction that I have received, Lordship.
Right, on the prayer made by Mr. H. Kalia, learned counsel for the,
I'm appearing for the government, Lordship. On behalf of Mr. B. Gogoi, he is representing the.
appearing on behalf of Mr. B. Gogoi, learned additional AG, who submits that they want to find a reply to the affidavit filed by the petitioner. List the matter after the vacation.
Either 4th or 5th February, Lordship.
Okay, 5th February.
Much obliged.
May please, your Lordship. Lordship, I beg to mention a writ appeal for listing this Friday is convenient, Lordship.
Regarding what?
Lordship, writ appeal,
Regarding what? Wait.
termination from service, Lordship.
Termination from service. You want to have a final decision on that?
Lordship.
You want to dispose it off finally or for what?
Lordship,
just for
order,
purpose of-
order, Lordship.
For orders, why? Not for disposal.
Lordship.
Huh?
For orders, Lordship.
Orders to do what? It will be listed for orders, but what are you going to do on that day? Are you going to pray for adjournment again, or you want to finally dispose of the matter? For what do you want it listed?
Lordship, the respondent council are not going to file their affidavit, Lordship.
It's a writ appeal. Where's the question? Writ appeal, you don't need to file any affidavit. You'll decide on the matter on the basis of what is there on the record. So you're appealing for whom?
Lordship, for the petitioner, Lordship, for the appellant, Lordship.
For the appellant. Okay. Who is for the respondent? Who is the party? Government or government?
Yes, Lordship.
State government?
Yes, Lordship. We are for the Assam Police, Lordship.
You're for the Assam police.
The-
Will be dismissed from service.
Yes, Lordship.
You want to dispose it off?
Lordship.
Writ appeal? Okay. Friday.
May I please, Lordship? Lordship, I beg to mention item number 33 of the supplementary list, Lordship.
35,
33,
33.
33, Lordship.
Yes.
Counsel for the petitioner M. Sharma is not well today, Lordship, so matter may be adjourned for the day, Lordship. And can it be fixed on Friday?
Huh? Item 33, when was it mentioned memo? Madam, what's happening? You mentioned it on Monday or Tuesday. We allowed you. Then you wanted to withdraw your mentioned memo. Then again, we wanted listed, we listed it yesterday. Then there was a defect, and then again you prayed that it be listed today. Again, we have allowed you.
Lordship,
And now again you have adjourned.
Lordship, the thing is that I'm not in this case, Lordship. The M. Sharma, Mr. M. Sharma has already on the phone, then he.
Only on the phone, but where is the
No.
lady lawyer who had appeared
No,
for
he's-
2 days?
She's not available.
She is also not available today. In which court is she in?
I don't know, Lordship.
Don't
because
know.
He spoke about me on the phone, Lordship.
She spoke to you over the phone, not Mr. M. Sharma.
No, Mr. M. Sharma has instructed her.
Oh, Mr. M. Sharma instructed her to instruct you.
So, no, Mr. M. Sharma is not well actually today. So
Tomorrow,
matter-
tomorrow,
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 Lordship.
on the prayer for adjournment made on behalf of Mr. M. Sharma, learned counsel for the petitioner. List the matter. Tomorrow.
Published it.
Lordship, as regards item number 3, can it be taken up on some other day?
Item 3.
The PIL matter.
I don't know. Who's,
Is there?
when,
Yes.
when do you want it?
Any date permanent, Lordship. We need to construct the file, man.
Okay, right. So you're challenging the notification. Yes. So you don't want that community to have land ownership. Right. Has been made a party, that's what. How now, how? Look, those persons whose right you want to take away. Are they parties here?
The petition is filed by a citizen, Your Lordship.
Maybe, supposing I want to take away a right. Would it be proper if I do it without hearing you? Should I be able to file a petition where you're not required to be heard?
I approach this honorable court on the ends of on behalf of the tribal, actually because of the influx and
Maybe we're asking you a simple question. You want to decide the fate of Mr. A.
I'm also included.
Huh?
Because I'm also part of it, that's
You're a part of that community.
the petitioner.
That is a different thing. You're a part of A. You want to challenge B's right. But B is not a party. You maybe belong to A. That doesn't matter. It's not a B. You're a lawyer right now. Don't say that I'm a part of it. You want to be a part of the petition as a petition person, you take off your gown and you argue. That's not a problem.
I'm talking about petition.
Correct. I know. But whatever it is. Anyway, right. Now on the prayer of the parties, on the prayer of the counsel for the petitioner, on the prayer made by Ms. B. Buyan, SC BTC. It is not objected to by Mr. A. Nazar, then counsel for the petition. This is the matter.
Any date, I'll take a file for it.
It will go to
With the
the thing.
Xerox.
But they are giving dates of February. They are giving dates of February, the TB one, that but cannot be school.
On February? He's agreed to.
February.
My lord, appearing for response number 6.
No, we're not issuing notice, nothing.
Wait, please, Your Lordship.
Yeah.
Matter is pertaining to PI, Lordship. From the local residents, Lordship. Two marriage halls are running there, Lordship, causing disturbance and nuisance to the people.
Where do you live? Do you live next to the marriage hall?
Lordship,
Huh?
Lordship, in the locality, Lordship.
Let us see who are you, which one? Where is the marriage house situated? Where have you said that you live next to them?
Lordship, this Mukut Chandra Deka is a social worker, Lordship. He belongs to that area,
He
Lordship.
lives
But
in,
but-
Madhab Deb Nagar, Maligaon.
Lordship, he is not within that area nearby,
Oh,
but
okay.
the rest of the 6 are, rest of the 7 are, Lordship, residents of the nearby areas, Lordship.
Is it?
Lordship.
Now, look at, now, where are the halls located?
One hall is located at Lordship, Kulhati area, Lordship.
Where is that?
Kulhati in Hazur Avenue, sir, within Hazur Avenue, both within Hazur Avenue Circle. And the
And
residents are from
this
Hazur Avenue Circle.
Hajo Revenue Circle,
Lordship.
that is Hajo Revenue Circle. And your petition number 1 is living where?
Lordship, within, he is not within that area, Lordship,
not
Hazur
within.
Avenue Circle.
What about
But-
number 2?
But the rest are within Hazur Avenue Circle, Lordship. All Lordship. Rest of them, Lordship. Up to number 7. 2 to 7 within that area. They do not have the courage to come for themselves, Lordship. Say to hold of some social worker, Lordship. There is a. Lordship, not exactly stay. Let them follow the rules and regulations, Lordship. Our High Court guidelines are also there.
Everyone.
Lordship. Earlier, Lordship. Lordship, he says, Lordship, what he says, Lordship, if I have to follow certain rules, Lordship, let them come under the scrutiny, Lordship.
No,
If,
no.
if Gunas Padmavati Bivah Bhavan follows the rules,
We want to stay both.
and I do not want to stay the other two also, Lordship. I think that they follow the rules, Lordship. Lordship, I pray for, but for the time being, Lordship, let them follow the rules. We have,
No, no. Marriage season coming up, everyone should be closed.
Everyone. we are-
Lordship. As your Lordship pleases, Lordship.
Yes, Madam President. He wants all closed.
No, I do not want closer, Lordship.
Then
I
what do you
want
want?
that they should follow the rules, Lordship. That is it, Lordship. That can be, notice may be issued, Lordship. They may be hard, Lordship.
We have a roving inquiry made just at your behest.
Just for these 2 halls, Lordship. Let them follow the rules, Lordship, and that is what I want, Lordship. I don't want to kick in the. Lordship, they are following the rules, Lordship. Lordship, Lordship, that can also be verified, Lordship. That can also be verified.
Private interests of the ventilated to public interest.
Correct.
That can also be verified.
You go file a case against them when you find, have something concrete. Don't ask for a roving inquiry. You find out what is wrong, then you come.
Lordship, we have filed representations before the authorities, Lordship.
No.
Representations are there.
You see, it has,
Let them answer them, Lordship.
no, you have to come with specific issues. What have they violated? You tell us.
Lordship, some rules was framed by the video, Lordship. And
Framed
those,
for-
and permission should be there, Lordship. License should be there, Lordship, for running Bivah Bhavan, Lordship. Our division bench order is also, Lordship. Lordship, the Honorable High Court went through it, Lordship, and allowed, Lordship. Lordship, let the representations,
Yeah.
Lordship, representations have been filed, Lordship. Let them dispose of those representations, Lordship.
Beautify the representation of.
That is the owner of Gunas Padmavati Bhavan, Lordship. Yes, Lordship. Lordship. Lordship, I told him that. Clear, Lordship. I clearly told him that he will also come under the scanner. Whether you want it or not, what he said is, if I have to follow the rules, same set of rules imposed by the district administration, why the others?
What PID is? What?
Lordship, everyone in the area should follow those rules, Lordship. Why only me, Lordship? He is not before the, when initially he filed that representation, I told him that. Lordship, now the other people have come forward, they say that yes, we are also feeling the inconvenience. Now only they want to file the case, Lordship. Initially, Lordship, the fault was between.
You see, what is the objectives for filing a PIL as laid down by the Supreme Court?
Lordship, for the public convenience, Lordship, some public anomaly relating to the citizens are being violated, Lordship. That
Either you withdraw and pursue this privately, or we're dismissing. And you can go Supreme Court and maybe try it. Third, Mr. M. Bakabat. What do you decide? Either our job will be take slightly longer, or it will make it shorter. That's all. Hardly any difference for us.
I leave it to you, Lord. Lordship, that can be given, Lordship. With liberty, Lordship, I will do it.
Correct. Third, Mr. M. Bhagavati, counsel for the petitioner, who submits that he may be allowed to withdraw the PIL and pursue the issue raised by him before the concerned authority. Miss M. Karma, learned counsel for the S. Karma. The respondent for the respondent number.
He appeals for 1, 3, 4, 5, 6, 6.
2, 3, 4, 5, 6, 7.
I'm for 1 and 6.
And Miss the S. Data appears for respondent number 1 and 6. The prayer of the petition counsel is allowed. The PIL is dismissed as withdrawn, with liberty as fixed.
With liberty to Lordship.
Pursue the matter with the authority.
Lordship. May I please, Your Lordship?
You pass the order. What is this? What is this PIL for?
Yes, Your Lordship. Hearing Your Lordship, regarding some beneficial scheme, the earlier Gaon Panchayat president, that is respondent number
What are those schemes?
scheme was construction of farm pond and another is plantation of valuable trees. Hearing Your Lordship, what happened, Your Lordship? I have given details in para 9. Para 9, I have given the details. She has selected her own brother relatives and in fact, without any construction or plantation, has usurped the money. And moreover, she has also selected some shown as beneficiary, but in fact, they have not get the benefit, Your Lordship. Para 9, I have given some of the details, Your Lordship. Para 9, page 12. If Your Lordship kindly stick, Para 9, page 12. I have given some of the details with serial numbers also.
So have you filed any police complaint?
Yes, a complaint has been filed by 2 of the beneficiary, shown as beneficiary, but in fact they have not given annexer 3 and 4, page 30 onwards.
Have you filed?
We have filed representation as a public.
No. Have you filed any FIR regarding
Yes.
the misappropriation
Oh.
or police complaint?
Yes,
anything?
2 complaint has been filed.
No,
before-
by you. By you.
We,
What do you mean we? How many are you all?
3.
Three.
Three.
So who has filed?
A complaint three has been filed by one Lalita Begum, who has been shown as beneficiaries but has not get any benefit, your lordship. Then annexure 4 collie,
Where, which page?
page 30 onwards. 30, your lordship. 30. May I read, your lordship? She has been shown as beneficiary at serial number
No,
61.
tell me. Just tell me.
She has been shown as beneficiary at serial number
I
61.
30, this page 30
30, your lordship.
has been filed by which petitioner?
She is not a petitioner. She is shown as the beneficiary.
You file your own petition. You file your own complaint. What is this?
Complaint has been filed before the
You have not filed anything.
Yes, we have filed before the district commissioner.
Where is that?
Yes, your lordship, page annexure 9, annexure 8, 9, 10, page 60 onwards, your lordship.
When was this filed?
This was, first one was filed on 18/3/2025, second on 17/5/2025, third is 6/3/2025. Then also,
Why haven't you filed it before the police?
also before the chief anti-corruption and vigilance, your lordship, annexure 11 and 12. That has also been forwarded.
You file it before the concerned police station. If there has been misappropriation.
Since
Then
of
you,
the benefit,
and if that is not followed, then you file it before the
in fact,
the judicial magistrate.
yes, judicial magistrate, two of the shown beneficiary has already filed, your lordship.
Huh?
Two of the beneficiaries,
Then if they've already filed, then why you, what's your interest? If the case is already there, what is your interest?
has been filed by one Srimati Lalita Begum, shown as beneficiary at serial number 61.
Look, if they have
Then
already.
again, your lordship, by one Fatwa Rahman,
Page,
your lordship may kindly see page 30, your lordship.
30.
30,
30 has been filed.
yes.
So what remains?
Then, your lordship, another your lordship,
So they have filed. Now where is your complaint?
then your lordship,
And who are you, by the way?
we are the social activist, and the
Social
petitioner number 1 is an advocate clerk, petitioner number 2 is a grocery,
Advocate clerk.
yes. And petitioner number 2 is a businessman doing grocery business, and petition number 3 is a heavy vehicle driver, your lordship. They are all resident of Middle Part 2 under
And-
Iracho government. Several complaints, several representation has been filed
You
before
go, you
various
should file your own police complaint first.
Since two of the shown beneficiaries already filed, your lordship, the case is going, but what we want, your lordship, let there be in some inquiry, your
Come
lordship.
to page 14.
Yes.
Sixth line from the bottom, please read.
Yes, your lordship. Further, the father of the respondent number 9, Abdul Karim, is an accused in 2 numbers of NDPS case.
No, page 14.
Yes, page 49.
1-4. It was with both Lalita. Both from the bottom.
Oh, from the bottom, your lordship. Yes, both Lalita and Begum and Fatwa Rahman have lodged complaint FIR before various authorities. Fatwa Rahman also filed a complaint case being so and so before the additional CGM against the respondent number 9, which is pending.
Which is pending? Huh?
50 that document.
You also want your name to be in the local newspaper. Huh?
No, we are not on that. We
So
we
this
want only
is already a complaint.
Hmm.
There is already a case pending before the CJM.
there is
Then end of the matter.
regarding the criminal case,
it-
your lordship.
why should
But
they-
let
why-
there be some administrative inquiry, your lordship, by the district commissioner, your lordship.
No. So who are you?
We are the conscious
You're a
citizen of that.
busybody, you're a busybody only basically.
No, we are only conscious citizen and
Mister, we are dismissing your request.
your lordship,
You want
at least,
withdraw, you withdraw. You see, this matter is already being taken care of. Heard Mr. R. Majumdar, done as counsel for the petition. Yes.
then
Any-
Lordship, I may be giving the liberty to withdraw you.
And do, okay. Mr. R. Majumdar, learned counsel for the petition. Petitioner says that he may be allowed to withdraw the PIL. Ms. S. Sharma appears for respondents number 3, 6, and 7. While Mr. S. Data appears for respondents
One,
number
2, 4, and 5.
1, 2, 4, and 5. The prayer of the petition counsel is allowed. PIL is dismissed as before. Next.
Your lordship, one thing can be done. We will file an FIR and after that we can have the
No,
liberty.
there is already a case pending. Why should there be 2, 3 cases over the same issue?
Meet with your lordship. Look, in this petition, a rule is under challenge.
Huh?
A rule is under challenge.
Yes. What is wrong with the rule?
Well, what happens, this concerns the service in the excise department by.
I read your name in the papers today, by the way.
Well.
I think, yes, I read your name in the paper. You filed some case in the Supreme Court,
Yes, my lord, challenging the.
anything to do with this foreigners.
Yes, my lord. That in Assam, there should be SIR instead of.
Yes. You wanted SR or something like that.
I want SIR.
You wanted SIR instead of SR.
In all the other states, SIR is going on except in Assam.
Okay.
12 states.
Yes.
Now, my lord, the recruitment to this, my lord, the post of superintendent of excise and inspector of excise is carried through, my lord, the Assam Public Service Commission. The superintendent of excise is, my lord, the grade 2 post, while my lord, the inspector is the grade 3. But the selection is common, my lord. After the selection is there, after the common selection, the persons are so appointed, either, my lord, the inspector or superintendent.
Direct recruit.
My lord.
Direct
Direct
recruitment.
recruitment. Now, what happens, so far as, my lord, the superintendent is concerned, 50% is through, my lord, direct recruitment and 50% by
Promotion.
promotion.
From
That is a-
deputy.
My lord.
From deputy.
From deputy, my lord. In the meantime, there is a, in between, my lord, there is a post of deputy, my lord. Now, what happens, my lord? For promotion, my lord, the total service required to the post of, my lord, deputy superintendent is, my lord, 5 years as inspector. For my lord, 5 years as inspector and 1 year as, my lord, deputy superintendent. So 6 years service is required.
For promotion to superintendent.
Superintendent. On the other hand, my lord, so far as this recruitment is concerned, the persons who has got in the grade 3, my lord, as inspector, they can also appear to direct recruitment. As a result, my lord, for the post of.
So even the deputy superintendent can appear.
Yes.
Then what is
The
wrong?
superintendent. My lord, the case of the petitioner is that, petitioners is that, my lord, because of the fact that once they are, my lord, appointed as inspector, the inspectors have to wait for 6 years to get promotion.
What is wrong?
My lord, because of this fact, my lord, the promotion prospect of the, my lord.
This inspector post is the entry post, correct?
Yes, my.
Entry post.
Yeah.
It is a grade
3.
3.
My lord.
And the deputy superintendent is what grade?
Grade 2, my lord.
Grade 2.
My lord.
And superintendent?
Grade 2. Deputy is 3. Deputy is also 3, my.
Deputy is also 3. So what is wrong? That's a higher pay grade most all.
High pay grade, my lord,
High pay scale.
the promotion prospect.
That's something good. The only thing that got to go to the deputy. What is wrong? I,
Now, my lord, this, my lord, the promotion, all these persons, my lord, they retire as superintendent, my lord, they cannot go beyond, my lord.
that is a different issue. You are challenging the rules. Let us stick to the rule.
Yes, my lord.
Let us
Now,
not
what
go
happens, my
beyond
lord,
what
your-
is going to happen.
Because of the fact that, my lord, the number of posts in the cadre, my lord, for instance, my lord, in inspector, cadre, my lord, there are 196 posts.
Ah,
Then deputy superintendent, my lord, 58 posts.
yes.
And superintendent, 26 posts.
So,
So, my lord, if the, my lord, direct by the inspectors who have, my lord, not got selected initially, my lord, when they competed, now they go to the, my lord, one
what do you
step
think
ahead.
happens in life? What do you think happens in the army? What do you think happens in the IAS or in any civil service or even in the judicial service? It's usually a paramedical structure. It doesn't go like this. It goes like this. It doesn't go like this also. Because otherwise everyone will be promoted all the time at the same time. As you go higher, there's lesser number of posts.
Yes, my lord.
Then
Now,
what
my
is
lord,
wrong?
because of this factor, my lord, the promotion prospect of these, my lord, persons.
You see, that is a different issue. How does it have any bearing with your challenge to the rules?
Uh, because rules provide that, my lord, 50% of the, my lord.
So, but,
post-
so no, you see, rules provide you the manner in getting to a particular post. Correct?
Yeah, yeah.
Now, what you are saying is that there are not enough promotional prospects. So basically, you are saying that what you're trying to say, I do not know, is that these rules restrict your promotion. Is it?
Yes, my lord. Because of the number of posts, because 50% of the
How does
posts
it
are-
restrict your promotion? I don't.
Because,
Where is your right to promotion? You have got a right to be considered for promotion. The rules provide
true, my
let
lord,
us
but
see the rules.
but
We are under challenge.
rules, in fact, my lord, I have quoted it, but the extra copy, may I, my lord, please? Very good. That's because of English.
Yes,
Rule 5,
5.
method of recruitment. Recruitment to the service shall be made in the manner prescribed hereinafter. Recruitment to the cadre of additional commissioner of excise, joint commissioner of excise, deputy commissioner of excise, and deputy superintendent of excise shall be made by promotion only. Then, my lord, sub rule 2, recruitment to the cadre of superintendent of excise shall be made A, by direct recruitment against 50 posts, 50% of the strength of the cadre to the commission, that this should be through the commission. B, by promotion in accordance with rule 11 and 12 against the balance 50% of the strength of the cadre of superintendent of excise from the cadre of deputy superintendent of excise. Now, my lord, looking at the, my lord, number of, my lord, posts in the cadre. So, my lord, in say, as superintendent, my lord, there is only, my lord, 26 posts. So that limits to 13. Okay.
Oh, we don't understand how there's a correlationship between the rules and your and how just because there's less number of promotional posts, why should the rule be declared invalid?
Because of the, my lord, arbitrariness in this, my lord, and it's not reasonable, my lord. From the same examination, my lord, the inspectors and the, my lord, superintendents.
I think Mr. Chaudhary, you know very well. I think you have seen much more service rules than I have. And I'm quite sure when you see the service rules, that as a person is promoted, there are less number of sanctioned posts as you go up. Let's come to your page 12 of your petition also.
What my trail is before.
No, let us go, let us see. I think you have very clearly filled that out also in your para 6. Superintendent of Excise is 26, correct? Then you have got Deputy Commissioner of Excise 2.
Yes.
Then you have got Joint Commissioner of Excise 1.
Yes.
Then you have got Additional Commissioner of Excise 1. Then Commissioner of Excise. It goes up like that.
It does,
So
my lord.
what you want is, there should be, supposing there are, say, additional deputy commissioners post or assistant deputy commissioners post, entry grade for the Assam Civil Service. Supposing there are 100, you want that there should be 100 chief secretaries post, basically.
No,
That's
that, no,
basically what
that
I'm
is not
saying.
my case.
There's not enough promotional prospect. As you go up, the number of posts to which they can be promoted lessens. That's part of
No, my
the
lord, since
design.
my lord, post in the superintendent cadre is, my lord, very limited. And that's why, my lord, the pay commission also advised, my lord, suggested that, my lord, there should be restructuring, so that, my lord, the promotional prospect is there. Yes, their promotional prospect has gone by. My prayer will be, my lord, either your lordship will.
You see, those issues are basically policy decisions decided per se with the finances and every other thing, a lot of other things. How can we take up those issues? That is not even a challenge to the rules. That is a policy decision you want made by the court.
No, my
Cannot
lord,
be done.
no, my prayer is that, my lord, these rules.
What you want is that there should be some more promotional posts created.
No, my lord, what I pray for is that, my lord, the post of superintendent of, my lord, excise should be, my lord, exclusively reserved for promotion.
For promotion. Oh, for promotion.
That is my case.
Oh, then there's no, okay, only.
Because of the limited number of posts and my lord, one selection process, by the same selection process, my lord, some people go, get the post of inspector, some people, my lord, go.
Now, great, even in the judicial service now, you must have read grade 3 to grade 1, grade 3 to grade 2 to grade 1 post. These are the promotional avenues.
Whether they in the, my lord, bar.
Now it has been raised to 25% promotion. You know, for direct, for this promotion by written examination and all. These are things that are.
No, that the latest judgment is that, my lord, the experience in the bar and the, my lord, in the judiciary, that total, that has to be, my lord.
That'll be counted.
That
Correct.
has to be counted.
And how many percent, how much percent are there? 25? 25. Promotion
but
is
there, my
given
lord,
50.
Yes, but there, my lord, so far as.
Yes.
So far as district judge is concerned, my lord, that is an
So
independent.
my brother is saying, if we apply your analogy,
My lord.
we cannot have any grade 1 from direct recruits. We cannot have any direct recruits as grade 1.
No, what my submission is that, my lord, those, my lord, so far as the judiciary is concerned, this is an independent cadre selection. Here is a selection by the same common selection.
Policy decision, then let them go.
My lord,
No,
let them respond to it, my lord.
no. No point keeping these.
Or your lordship.
This is in the realm of policy. Sorry.
My lord,
Yes,
I
we can
really
go on,
rely
we'll
on-
decide, we're deciding it now. Sir.
then, my lord, may I rely
Yes, yes.
on. In fact,
We'll submit one thing, my
Yes,
lord.
yes, yes.
Page 12 of the petition, my lord.
Yes.
So basically, if my lord sees the structuring,
Yes, yes,
the bottom is the inspector of excise, my lord.
yes,
It is in class 2. Then serial number 5, it is superintendent of excise.
yes.
For them, there is a combined examination.
Ah.
So these petitioners, my lord, they were selected as inspector of excise and some others were selected as superintendent of excise. Basically,
Correct,
it's a case
correct.
of heart burning, my lord. There is nothing wrong with the rules, my lord.
Nothing
They were
wrong.
inferior in the selection process, so they were appointed as inspector of taxes. And if we go by their prayer, my lord, if 26 posts are, suppose assuming 26 posts of superintendents are reserved for promotion, then also 196 cannot, my lord,
Cannot go.
ban all these posts, my lord.
Correct.
No,
There is no logic, my lord.
what happens is that, my lord, they get a jump, my lord, two-step jump, my lord.
What to do?
Knowing well, my lord, this was the rule in
This is
force
what
when they
happens in life. That is what now happened now with the new judgments, even with the grade 1. I mean, in the judiciary. Now, even those in grade 3 can jump to grade 1.
Yes,
As per the latest judgment.
the last judgment, my lord.
Yes, how does it help you?
Yes, my lord, knowing well about the structuring system, my lord, they applied
Latest
for-
judgment of the Supreme Court, you read it.
I wanted to rely on some judgments, my lord. those-
Latest
those I-
judgment is there. Latest judgment of the Supreme Court with regard to the judiciary is there, where grade 2, grade 3 person can also apply for grade 1 post.
No, my lord, I was talking about the, submit about the stagnation.
Grade 2 persons, I think, yeah. Like for grade 2 persons can apply for grade 1. Yes.
I wanted to, my lord, place some decisions on the stagnation part, my
No,
lord.
no.
Or maybe your lordship may direct them to dispose of the
Yes,
representation.
we're disposing it of. It's
Dispose of
not
the
that we have to issue notice or we have to.
My lord, no, I'm, my lord, imploring about, my lord, disposal of the representation.
Unless we find a prima facie case, no problem. Wastage of time.
They could have,
For
my
them
lord,
also, and for,
they could have appeared again in this combined examination, my lord. Next time they might have cracked the superintendent examination.
you try the second time.
Yes, my
You
lord.
see what we have noticed. At least I have noticed in some states, those persons who do a lot of these tests, they're usually the ones who are selected. So you do it the second time, third time, you'll get it directly. Then you will complain. What have I done?
In fact,
I have blocked my own path to go directly there.
my lord, these persons, my lord, they're used for, my lord, day and night police duty, my lord. And in the
So
gather of-
they want to sit in a chair, in the superintendent's chair, and direct others to do the day and night duty. That's what everybody wants, part of life. But
It's basically hard burning.
nobody wants to do night duty at night while they can sit
there
9
is
to
no
5.
burning of heart because nobody has superseded.
My lord,
us
one of my
as
friend,
yet.
my lord, childhood friend,
Ah.
she was selected for Indian Police Service in 2007. She was not happy. She again appeared in 2009. She got IS, my lord. These petitioners could have, my lord, participated
Okay.
again.
Right.
The last prayer is, my lord, your lordship, I direct them to consider the representation at least, my lord, their representation is pending, my lord. And pass an order, my lord, whatever.
Look, only thing we can say is you withdraw and you pursue the matter with the authority. That's all.
Yes.
We're not. What? Other we're disposing it other.
On the representation, my lord,
What? Yes, no, what do you want?
Withdraw with the.
Okay, right.
record-
Mr. M.K. Chaudhary, learned senior counsel for the petitioner submits that he would like to withdraw the writ petition and take up the issue with the concerned authority.
Obliged.
Mr. Ian Goswami, learned additional AG appears for the state. The prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn, with liberty as paid for.
Close this withdrawn, my.
Huh?
Close this withdrawn.
Close this withdrawn.
The word dismissal, my lord,
Okay, close.
obliged.
May it please your lordship. My lord, my lord. Oh,
DR Gogoi is, Advocate DR Gogoi is brother and wife.
Rasbang similar. Oh,
Malavika, Osip.
my lord, there is some urgency
What to do
and Chief Justice is also not there.
next week? No.
My lord, I'm told, my lord, they will take over the property. Take over the.
What to do?
No, my lord.
No. I'm not, I cannot.
No, I'm not, I'm not praying that your lordship, Justice Nair should take it. If it is possible in the second half, my lord, a bench can be constituted.
No.
My only prayer is, my lord, DRT is
I-
not sitting. That's the only, otherwise, because under section 17, these are applicable. So, my lord, there is no notice, no nothing. My lord, the rule 8.5 has been violated. My lord, all that I'm saying is, till 14, DRT is not, the presiding officer is not there.
Right, list this matter before some other thing, not before one of us.
My lord, I will pray if at 2 o'clock, you know,
No. No, I cannot do that. Who is the power? You know that very well. I don't want to I don't want them to have an impression that I'm acting too big.
what we can do,
Yeah.
Lord, we can request the registry, my lord.
That you
Pick up
do,
the
that,
matter at
that
Chief
you
Justice.
do, that is a different issue.
Or that's the only problem.
That's the only-
DRT is not sitting with that. Otherwise, they wouldn't have trouble, your lord. Yeah. My lord, here Union of India was supposed.
Item?
11. My lord, here our prayer was, my lord, invariably every cases are being referred to foreigners tribunal. My lord, the law is, my lord, if a person skillfully sneaks into a country, he is not entitled to the due protection of law. There are two judgments of the Supreme Court. One is, my lord, Sarvananda Sonowal, and other is, my lord, that Arunachal Pradesh case, where the Honorable Supreme Court said, my lord, in terms of, I think it is clause 13 of the International Covenant, a person at will is not entitled to due protection of law. That is why, my lord, in Sarvananda Sonowal, the Honorable Supreme Court says that those who enters the India with a valid passport and visa, their cases can be referred. But the person who stealthily sneaks into a country, he is not entitled to due process of law. Therefore, my lord, it is not necessary. Invariably, case has to be referred, case has to be sent to foreigners tribunal. That is the point. My lord, notice was issued to the Union of India, my lord, on last occasion.
See, that is what the state is doing. They're sending.
That is what I was telling.
I think it was a-
Not,
it was a-
not really, my lord.
Declare void and pushing. Put back. Right, put. Put.
In fact, my lord, yesterday, the Honorable Supreme Court has taken a very strict
I
view.
know. Rohingya.
I wish that view could have been taken in that 6A petition. So, my lord, this is very,
But wasn't there a decision, wasn't there some statement made by the CM
CM, my lord.
in this case?
No, yes, he said, but the CM statement is not, end of the day, it is the government of India who has to lay down a clear-cut policy.
No, but
Yes, the
there-
power of the
the
central
state-
government is delegated to the deputy commissioners. So, my lord, but the end of the day, there are lakhs of cases where references are taking place.
No, for those, you see, where there's, those cases where it's already pending adjudication, that'll be a problem. But those cases where there is no,
No, at least in the new cases, my lord, they should not refer.
but isn't there a?
At least, my lord,
No, no,
some
isn't there a
observations to
statement
that
made?
extent, my lord. At least the new cases. Regarding the old cases, lordships can take a call at the time of hearing. Regarding new cases, my lord,
Who is for the state? Yes.
state, my lord, notice was not issued to the state on last occasion.
It was
Perhaps lordship would like to issue notice to the state.
Right. The change Chaudhary, the learned senior counsel or the petitioner. To stop it. That. The. Continued reliance by the state police on the foreigner bracket tribunal bracket order 1964 for detection of illegal migrants in Assam. Should be set aside due to the continued illegal migration of foreigners from the neighboring state. Neighboring country. They accordingly raise for a directive to be issued to the respondent to implement the mandate of the illegal migrant bracket expulsion from a Act of 1950. By empowering the executive authorities to detect and deport illegal migrants without mandatory recourse to the foreigners tribunal. Foreigners tribunal. Yes, anything, Mr.
Lordship, I'm awaiting my instructions, but if a lordship will come to page 29, his for setting aside his prayer was a little different, lordship.
No, Lord, I have got other prayers also. Amongst others, this is the main relief I am seeking.
Lordship, I am awaiting my instructions.
Mr. Arcady, issue notice returnable there. 4 weeks, Mr. Arcady Chaudhary submits that he has not received instruction till date. He is awaiting instruction. Mr.
My lord, I am paying for restaurant number 2, 3 and 4.
Mr. DK
DK
Sharma,
senior.
the additional senior government advocate,
Appearing for 2, 3,
appears correspondence number
2,
2, 3 and 4.
2, 3 and he submits that he will obtain instructions in this week, by the next week. But this is the matter. We would- February or
Muslim Mandal will also have to be factored in here. Case of that full bench decision.
Yes.
Because therein also they said that you will have to go how it will be done. So maybe it may require you will have to place that and then.
Or maybe a reference to larger.
Rather.
Correct.
My lord, yesterday he filed the affidavit in opposition at 2:30. And that was served upon my clerk, my lord.
We have filed
Yesterday,
a affidavit in opposition.
in opposition yesterday at 2:30. And that was served upon my clerk, my lord. And that was served upon my clerk, my lord. And accordingly, I received that particular copy today morning, my lord. I like to find the affidavit in reply.
Why, what is there to file? Why do you have to file a reply? What is the requirement?
My lord, so far this petition is concerned. In that case, my lord, this matter may kindly be disposed of from this one. My lord, your lordship will find first of all.
Where is your affidavit?
Yesterday we have filed, lordship.
It's not there.
Let it come up next Monday.
Okay, we'll list another date.
Monday, lordship. Monday.
I don't think Monday would be.
In the meantime, if my learned friend wants to.
Let him file, let him
Yeah.
file.
Yesterday we have filed.
Okay, right. The respondent bank has apparently filed the affidavit yesterday. Registry to place the same on it. The counsel for the petitioner submits that he would like to file a reply affidavit. This is the matter.
Obliged.
9 January. The same is allowed. This is the matter on 9 January. Yes. Oh, yes. Item 16. Yes, so the child court record is in another criminal appeal.
Another criminal.
So we will call that criminal appeal. And
Then I will place the my lord misstatement. There is I have for my lord bail my lord.
I know.
Because it's a very good case for bail my lord, because the last seen together theory applied only on the basis of last seen together. My lord. That means there is not that is not a my lord.
We have
Yeah, you have,
copy this. Copy.
you have file.
Copy is available in us. A copy is served on the
Huh?
right? Is that no? Full effective.
Yes.
I does me.
But it is the criminal appeal, not IA.
I does the product.
Okay. Okay, it's with file. Okay, right. As per office note, dated 27/11/2025, the TCR has already been transmitted to this court in connection with criminal appeal 104/2020.
Another case, my lord. Yes.
List this matter on Monday along with criminal appeal 104/2020.
April.
No, 2024.
Developer.
Kindly pass over timing. My senior is 2 to 10. What a timing.
Rakesh Paul matter mein.
Huh?
Rakesh Paul mein APSC matter mein.
After some time.
Paper book is not prepared.
Not prepared.
But today it was for the consideration of the bail because 50% has already been completed. Lordship. I have that sentence.
No, but 50% as an under 50% of the sentence.
Sentence.
But that is with regard to under trial. Whether that
50%.
No, that section, it will not apply to a convict.
That 1/3 will perhaps not be applied, but 50% lordship
Huh?
perhaps there are some judges. My senior will address lordship.
No,
I just want for
anyway,
some time.
the other issue is, my brother here is having some difficulty.
Then it's
That
then
is
lordship
why.
may fix a date.
So because of that, what we're doing is at least we can pass an order for making the paper book.
Paper book is quite voluminous. I think it will take
So
a
it's
lot.
not required.
It's required, but it will take a lot of time, lordship. May I kindly see the volumes, lordship.
No. So the issue is this. If you say paper book is not required, then we won't we won't make a direction for making a paper book. It depends upon you. But if you say it's a necessity, then we have.
Necessarily it is necessity is there mein. Otherwise it's difficult for them to come.
No, they are saying that's not required.
Because there are other cases also are there, my lord.
I am not on that.
More than
lordship.
50
What I'm
appeals are
trying to impress with your lordship, that because of the voluminous documents, 70 witnesses and huge numbers of documents, preparation of the paper book may take a considerable period of time. My IA may be taken up.
Maybe, but at the end of the day, we have to hear the appeal also.
Yes.
IA is not the end all of everything. Supposing IA is rejected, then what do you do? Then you'll be the first person who will be shouting that paper book should have been made at the earliest. Right. As but there is nothing to show that paper book has arrived. I mean, the records have arrived.
PCRs, I don't know.
In collected appeal, it has been come.
Why is it not reflected here? It's not reflected.
Not, there are other appeals are there before the single bench.
No, that because they're 10 years. It is like with a single bench.
So has the PCR been directed to be prepared in the other case? You got no idea.
No, not has been prepared, my lord. There is no order such.
So we tell them to prepare the.
Actually, my lord,
Is it necessary?
that's my lord. It's not necessary for the present.
No, no, not.
No,
only-
for merit, merit.
for the
Yes,
appeal.
yes.
That-
Maybe, yes, correct, my lord. But for the IA, my lord, as per the provision under the statute, I have completed half term. Half term means 7 years, 3 days I am in custody. As on today,
Under which provision?
I'll tell under 436A of the earlier CRPC.
Now let us see 436.
Can you see the CRPC? But please note that maximum I was 14 years. 14 years,
436A
Yes.
pertains to under trial.
right? I have an answer to it, I know. But by a judgment of the Supreme Court is Santanu Kumar until it is also if applicable to convict, which our division bench also relied on Santanu Kumar until, and it has been said it will apply to convict also. I have the judgment. So this was the issue, my lord. I will show it. 90. My lord, only we are.
You cannot take it up.
My lord will not, that's why I said only that this all may have some complicacy, my lord, that's why your lordship.
I do not know.
Why?
One thing that will be clear,
Yeah.
the papers that we have,
Yeah.
it is made in the form of a paper book by one of your, I think, okay for the purpose of hearing the appeal.
There are more records and documents, that is very,
Huh?
Yeah. my learned friend said there are more.
There are more documents.
Yes, correct.
So now who is going to pay for the cost of the paper book? It's going to be voluminous.
We have to do it, but earlier our High Court man paper book was prepared by the court, but there, I know, I remember, that if it is urgency from our side, court used to give a direction that you have to pay from your own. At the cost, we'll do it, that's leave it to us, my lord.
Okay, we'll direct the registration paper.
But only for IA, as your lordship, my lord, I think that's why I said that my lord should not take up, these are all matters, these are all sensitive matters, I say. Because Kaushik Kolita, I will tell, Kaushik Kolita, I am representing from one of the contender today. Your lordship represented before division bench, Kaushik Kolita in Bhanagar was the co-accused in Bhanagar. And subsequently he has been discharged. Acquitted because 120B has been there, 120B. So I think that's the reason why I pointed in the morning itself. But 7 years, my lord.
Right. List this matter before some other bench, comma not before one of us. Bracket you write Justice you can have. And then you write, as the TCR has arrived, registry to pay the paper book at the cost of the appellant.
Correct. My lord, I am.
In the appeal, my lord, our names may be shown, my lord.
Mr.
P. Kotoki,
P. Kataki appears for,
as a special public prosecutor.
a special public prosecutor appears for the state.
IA may be listed.
When?
No, IA is there.
List the matter.
So IA.
List the matter after 2 weeks.
After that,
After 3 vacation, lucky for 7 years.
After 2 weeks. Not 2 weeks.
Yes. He said after vacation. He want that the jail should be flooded. That's why I said, as per direction of the Supreme Court, I have brought judgment.
He's doing a good job there
Where?
in jail.
He's
Your
my-
client.
All my.
He's buying them musical instruments.
yes, bhajans are
giving
good.
them
Were there, my lord.
lessons,
There. My lord,
yoga. He's
nobody,
yeah.
I think nobody wants to be in a jail.
no.
By compulsion.
I'm just saying that
they
he's
are in
doing
jail.
good for others.
These are, well, let's pray to God. Never happened to anyone, my lord. So after 2 weeks, 2 weeks, get a date. Can be,
No, not it, not it.
it's okay, it's okay. We'll mention it. Deeply of it.
May it please your lordship, as per office note dated 1/12/2025, lordship, service not complete, lordship.
Too many minutes.
Service not complete, lordship.
Item?
Item 18, lordship. We may be allowed to take fresh step, lordship.
Item 18. I think if you take.
Lordship.
Right. Mr.
Keyboard law, Lordship.
Keyboard law. Fair thought. Petition. As there is no return of any card or unserved notice from the respondent number one and petitioner shall take fresh steps for service of notice upon the respondent number one and
Lordship.
by speed post within 3 days.
Lordship.
List the matter.
Lordship. Oblige, your Lordship.
Medical report was called for. We've got the report, Your Lordship. DD of Nakutu. Accused appellant is suffering from upper gastrointestinal bleed, grade 2.
Just a minute, let us see the main appeal.
Yes.
This is with regard to POCSO.
Yes, ma'am.
Yeah, paper book is ready, Your Lordship. Can it be for hearings?
Lordship, it is, the objection is filed by the learned PP on the last court date, honorable court date. And today is fixed for hearing for I.
Okay.
Who they filed it,
We
sir?
can hear you.
Lordship,
Filed it.
Give me the IA.
Lordship, it is a simple case of murder, Your Lordship.
Simple case of murder.
Yes, Lordship. It is a very unique case, and I have first find it is along with section 379, 380 of IPC or
Paper book.
380
Paper
of
book has got 2 volumes.
objection of the IA has been filed,
Paper book
and I
is-
have the objection of the
Who has
of
filed
you.
it? Who is
This
the
one.
counsel?
this one.
Thank you.
Lordship, 380 of IPC. And interestingly, Your Honor, there are 3 accused in the prima facie case, and Asif Ali, Aizul Ali, and Sofiq Ali. And Asif Ali was acquitted by lower court, Your Lordship. And interestingly, the paper book submitted by the learned PP has relied upon one simple witness, PW number 22. It is an interesting fact, Your Lordship. In this particular version of PW 22, he has spoke about the commission that he has seen. Interestingly, that the Sofiq Ali was caught, Your Honor, and and he was been
22.
PW number 22, judgment copy, page number 36, and paper book.
Page 72.
Lordship, judgment copy, in judgment copy, page number 36 of the lower court, and page number in filing is page 44, Your Lordship. And point number of judgment copy 54, Your Lordship. 54 number point, Your Lordship. PW 22, Mr. Provin Soikia, he's been cross-examined by the lower court counsel, and he has stated that there are 2 persons, namely caught by the PW 22, Provin Soikia, on that particular occasion. And he is telling lie, Your Lordship. There's a fact. In the FIR, Your Lordship, you can see there is a clear sign of darkness. This mentioned in the FIR that the commission of the crime was occurred on 28th of July, 28th of June 2025, 2023, Your Lordship. Let's read the
Have you got the evidence of PW 22 with you?
PW 22, Your Lordship. He has stated.
Yes.
Have you got at page 73? Paragraph number 9. Paragraph 9. Mr. Counsel, you don't have a paper book.
I have not yet got the paper book because it's only hearing about IL, Your Lordship.
Give a paper book to him.
A paper book I have not yet.
Is that 1 and 2? Volume 1 and 2 or something? Is it? Why is it, no, just a minute, wait, why is it so thick? Why is this one so thick and others so thin? Huh? No. Oh. Double thing. Is it not thick? Give it to him.
Lordship, in the FIR, in the FIR,
Come to page 73 of volume 1.
Can I read, Your Lordship? Dulal Soika is my cousin, son of father's elder brother, and the issues of Dulal Soikia, a complainant Gokul Soikia, and my are situated adjacently, and the two accused persons seen today in the BC had crossed the steel cord from the pen of Dulal Soikia on the day of occurrence. Point number 5, when the two.
No, come to 9, straight away.
Come to 9, yes, Lordship. Jotin Soikia, another nephew of mine, also rescued the place of occurrence with me, and the king accused Aizul Ali assaulted Pranab from being with a knife and run away towards the filed leaving the bike, and they had brought them. They brought there, and therefore I could not
So out here there is an eyewitness.
retain there. Lordship.
So this PW 22
Yes, Your Lordship.
is an eyewitness
Yes, Lordship.
to you
Yes, Lordship.
stabbing the deceased.
Even though, Your Lordship, it is an eyewitness, but there is a contradictions on the a part of the FIR, and subsequently the witness come to Honorable Court, Lower Bellow, Learned Court, and he gave the evidence. But it is a clear sign of derelictions on the part of the IO, because the fact that there are 37 witnesses examined by the prosecution, and even though even the 37 witnesses, only one is been right. How strange, Your Lordship, and subsequently, Your Lordship, he has come.
No, you see, all these things are done.
Lordship.
All these things are done surreptitiously. No one does an illegal act out in the open.
Lordship.
It is done in the cover of darkness. It is done when people are not around.
Lordship.
We are lucky that there is one eyewitness at least. Otherwise, they would never have been caught.
Lordship.
Now, what is wrong with the evidence given by PW2? That should be your
22.
question.
22, Your Lordship. That objection is that, Lordship, when he come before the court and give the evidence, when we see the FIR, there is a huge contradiction, Your Lordship. In the FIR, it is specifically mentioned about the darkness and who has committed the theft. Nobody seen, Your Lordship. And on the particular occasion, one other of the.
Now, if you say that, you look at the cross-examination of PW22
Yes, Lordship.
in the next page, page 74, you come to para 5.
Para 5. Para 5. I've seen the.
It is not a fact.
Para 5. It is not a fact that when I flashed the torch, I saw the two accused persons fleeing in fact, and when I flashed the torch, I saw Pranav catching the fat accused and the thin accused assaulting Pranav from behind with a small dagger type knife, like weapon, your lordship. There is a huge possibility of doubt, your lordship, on the part of the evidence of PW Pindi as a fact that he has not properly seen, he has flashed the torchlight, but he has not seen the dagger. Dagger, your lordship. There's a huge.
No, how
doubt,
can you
your
say
lordship.
that? How can you say?
And another point is that, your lordship, it is not a fact that when I flashed the torch, I saw that two, plus lordship, in the 161 statement of the PW Pindi has been very relied upon, your lordship. What he said before the police. If that statement is similar to this one, then it will be a fact, your lordship. The huge question of law, your lordship. And if the 161 statement of PW Pindi and the 14 Soikia is been similar as what is stated before the lower court, then it will be a very good question of law, your lordship, to convict the accused. And interestingly, one accused has been acquitted. Your Asif Ali was acquitted. And interestingly, my client was been imprisonment for life, and under the imprisonment only for 7 years. 7 years, your lordship, on the offense of theft. It's a question of law. My one client is convicted for 7 years, and other was imprisonment of how strange, your lordship. It is even though if the commission of the crime is in the darkness, is been occurred, then definitely the two accused have been convicted for life, and one has been convicted for life, and other was 7 years, how strange, your lordship. And this caused a similar bit of doubt on the part of the mind of the, on the part of on me, or there's doubt here on the part of the lower court below also, your lordship. There is a doubt on the lower court's mind that accused Safiq Ali committed only theft, and my client committed murder as well. So how strange, your lordship. And with the versions of the PW 22, it has been only relied upon the 161 statement of this particular point, your lordship. 161 statement of the differ, and 161 statement particularly says whether he is telling lie before the honorable court below or not, your lordship.
The thought that it has not been examined with regard to its statement being that this.
Excuse me.
I spoke. Yes, madam.
Lordship, as your lordship is aware of, only one witness can be the sole basis of conviction, your lordship. Let him try his luck in the.
In the
hearing.
appeal,
Yes.
correct. Though it will be an uphill task. You see, the thing is that even if you try to say that his statement under 161 is at variance with his testimony, the fact remains that nothing has been put to the IO with regard to that aspect.
Lordship, in disposal of the appeal, bail may be given to my client, your lordship.
No. You try your luck during the appeal. Right now, there's no case.
On that benefit, your honor, give some.
22 says, 3W 22 says,
Only
on the
one
light of the
witness.
torchlight,
Yes,
on the light given by the torch, he saw this thin one, the thin one stabbing the deceased.
What is the thin line of margin, your lordship?
Huh?
That benefit of doubt must given to the.
There is no benefit of doubt to be given. When there is when there is an eyewitness, what more do you want? One eyewitness is enough.
Lordship, there is a contradiction in the FIR. And in
It's a
the,
contradiction in the FIR. FIR is not evident.
And in the 161 version, maybe.
You see, how do you see, there is a certain procedure for, declaring a witness to be not reliable. You have got to confront the IO with regard to the statement of the witness made under 161. Out here, there is nothing done to that effect. So where is the question of this court holding that PW 22 is not a reliable witness?
22 is a reliable witness as the fact that he has not stated properly. And 161 statement may be completely different from that point.
May, you see, the question of may, you have to prove that, no? You cannot say may. You'll have to be positive that it completely differs, and as such, he is not a reliable witness. But you've got to show that. You try your luck during, right? Heard, Mr.
A.H. Bhuya, Lordship.
A.H. Bhuya, learned counsel for the appellant. You're amicus or?
No, Lordship.
Learned
From my
counsel for
client.
the appellant.
On behalf of my client.
Who submit that this application under section 430 for suspending the sentence inflicted upon the applicant pursuant to his conviction by impugned judgment dated 23/6/2025. Part 5. The sections that Lakshmipur at North Lakshmipur is section case number 230 bracket NL 2026 under section 302 IPC. First up, accordingly submit. No, next up. The applicant counsel submit that there is a contradiction in the contents of the FIR vis-a-vis the testimony of the prosecution witness. That's all. Next up. Ms. Bhuya on the APP on the other hand submit that when there is an eyewitness to the crime in question, comma, when there's an eyewitness to the crime in question, comma, whose evidence has not been shaken, comma, it would not be proper for this court to suspend the sentence. Full stop. We have heard the learned counsel for the part. The evidence of PW 22 is to the effect that the thin person had stabbed the deceased when the deceased had caught hold of the fat person. Where is that? No, the PIP. As a thin person, you put in bracket, you put appellant, okay? The other person is not here, Moon is not. Here. Moon Changma is there, 27, 26, PW. Next, right. The evidence of PW 37 shows that the shows that PW 8 and 26 had identified the appellant during FTI. But madam, there's no identification in the doc.
Oh, doc identification. Let us see PW
Slide
22.
22.
Lordship, the two accused persons seen today in the VC had come to steal gold from the pen, page 73, para 4.
Oh, okay. Okay. Okay, in the read.
Coaching Mari class.
Okay. PW 8 and 23 had also identified, had also stated in their evidence that they had seen the they had seen the appellant and the other co-accused riding away on a bike carrying the stolen gold. PW 22 has also identified the appellant to VC on the date of giving it. Considering all the above, we're not inclined. Suspend the sentence and grant. The application is accordingly rejected. However, the observations, any observations and finding made by us in this order shall not be constituted to be the final finding or observations made by us in disposal of the appeal. In the appeal, you write, as a copy of the paper book has been given to the petitioner's appellant's counsel today. List the matter for hearing. January.
Date, Lordship.
When do you want?
After 1 month, Lordship.
After
Date of meeting,
end of January.
27.
Apply.
Right, please, your lordship. Okay, in this case,
Respondent,
Sir, my lord. Copy this, sir? Sir, copy? Tara, dissenting.
yes,
Sir, an objection also filed yesterday.
objection filed by you.
amicus may be appointed.
No need, fight. Why should we have fight?
Okay.
We'll have a better chance. Without one less lawyer on the other side. Oh, they have no means to engage a lawyer.
They said, my lord.
But
No, no.
I, on behalf of Census, that we have a forward a copy. What is
No,
it?
that's ours, my lord, communication. They are to inform, my lord.
Oh. And that I want to. Not legal. Okay. So when do you want?
My lord, after 2 weeks, my lord, we will file our IA for bail, my lord.
No need, we'll hear the entire thing. We'll hear it next week also. You
PB
don't
is
have-
ready, your lordship.
Huh?
Paper book is ready.
Paper book is ready, there's no need of bail.
We have not received paper book, my lord.
Paper, আমি আজকে পেয়েছি।
Have we got an extra? Give an extra copy. Please.
Well, it's after a week, my lord.
Huh?
After a week, my lord.
Okay, give it to me. Right. A copy of the paper book has been furnished to Mr.
UU Khan on behalf of A. Ahmed.
To Mr. A. Ahmed, learned counsel for the appellant through Mr. UU Khan. Ms. P. Buyan submits that she has already been furnished a copy of the paper book. The letter dated 34/25 issued by the OC Khawang Police Station is to the effect that notice has been served upon the mother of the victim. In view of the above, notice is deemed to be served upon the respondent number 2. As the matter is fit for hearing, list the matter for hearing on whenever. Give a date.
After. Deeply.
For the first time, Lordship, 390.
Ms. P. Sharma, learned counsel for the appellant. Submits that there is a delay of 395 days in filing the appeal against the conviction of the applicant under section 447/34, 325 34 and 302/34 IP. Ms. B. Bhuyan submits that she has got no objection to the delay being controlled. Considering the sufficiency of the council and keeping in view the reasons for the delay. The delay of 395 days is condoned. Registry to list the appeal, I have accordingly disposed. Heard with
P. Rabha on behalf of Ms. Ava.
P. Rabha on behalf of Ms. A. Gayan, legal aid counsel for the applicant appellant. The application is for condoning the delay of 27 days in filing the appeal against conviction of the appellant under section 376 AB / section 4 of the POCSO Act. The applicant was thereafter sentenced under section 4 of the POCSO Act. Ms. B. Bhuyan submits that she has got no objection to the delay being condoned. Accordingly, the delay of 27 days condoned. Registry to list the appeal. I has accordingly disposed. 27 days, huh? Okay, this one,
26
right.
days.
Mr.
AK Gupta, ma'am.
AK Gupta, learned counsel for the applicant. Praise for condoning the delay of 26 days for filing the appeal against his conviction under section 376(3) IPC, read with section 4(2) of the POCSO Act. The applicant was thereafter convicted, sentenced under section 376(3) IPC. Ms. B. Bhuyan submits, no objection. The 26 days. Okay.
Obliged.
Lordship, 771 days of delay.
Who is appearing for the other side?
And there is the order dated 17/9.
That exercise,
The respondent died and
17/9. Yes.
therefore the appellant to file affidavit on this regard. I am the respondent, madam. Who is the appellant?
Lordship, that needs to be filed. Well, council changed also, Lordship.
Okay, right. Bhuyan, the learned counsel for the appellant PTC
My lord.
shall file an affidavit indicating the date of death of some of the respondents, to enable expunging their name from the array of parties, in terms of the order dated 17/9/2020. This is the matter. Give a date.
After 10 days,
Yeah, next year.
next year.
Memo of appeal has not charged to me. Memo of appeal.
Let it be condoned then.
You give before that.
The-
If you want one thing, I'll tell you.
My lord.
The DB1, usually they want to know the fact of the
Ground, madam.
the merit. So he has to be ready.
I'll
You'll have to be ready. So so your condonation application
Along with
will depend upon the facts of the case.
Please.
The merit.
Thankful to your lordship.
obliged.
Please don't give me a dinner. Yeah. Please, your lordship. Okay, lordship.
This appeal we filed an IA number 3659 of 2025.
How many days?
Lordship, first is for substitution of the names of respondent number 5 and 7, my lord.
Okay.
Lordship, respondent number 5 and 7 have passed away in the meantime, lordship.
Oh.
Lordship, if I may, Lordship, I'm appearing on behalf of Counsel Mr. D. Gogoi. Lordship, as per the instruction I have, Lordship, he wants to file an objection to that IA number 2602, Your Lordship. That's another IA.
That's a different thing. We are on 3659. So you have got no objection to that. Right. Heard Ms. P. Barwa, learned counsel for the Applicant,
Applicant, applicant.
applicant, appellant,
Applicant, applicant, madam.
who submits that. The names of the respondent slash opposite parties number 5 and 7 should be replaced, should be substituted by their respective legal heirs, as they have both expired on
What's it? Legal air number 5.
just a minute, 5 is
Actually, S.5 expired on
Yes,
10/3/2024.
expired on 10/3/2024 and 27/9/2024 respectively. Mr.
P. Khatoniya.
P.
P. Khatoniya.
Catania, learned counsel appearing for
Lordship,
for all the respondents.
no, Lordship, apart from 5 and 7, the other private respondents, Your Lordship.
Of everyone,
No, not 5 and 7, Your Lordships.
not for the- And what about the government
Revenue Department and DC. no?
for the revenue department and DC Demaji? Okay, appearing for respondents number 1, 2, 3, 4, 6, 8,
9 and 10.
9 and 10
And also 11 also.
and 11. Submit that he has got no objection to the application being allowed. Okay, in view of the above facts, the and the applicants, is not the applicant, the
Applicants.
page 9. The names are page 9. Are allowed to substitute, no, are allowed to substitute the respondent slash opposite parties number 5 and I is accordingly disposed. Then in the other condonation delay, how much?
2602.
How much?
Actually, 126 days matter.
122.
He wants to file an objection to that, Your Lordship. Sometime maybe granted to him.
What? What for what?
So I'm not in this case. It's just the instruction I have, Your Lordship. So a little bit of time may be given, Your Lordship. He will file it meanwhile.
This matter has been pending for quite some time. Anyway, right. Mr. D. Gogoi, learned counsel for the private respondent is granted 2 weeks' time, as the last time. To file, to file written objection. Ms. P. Barwa shall file an amended cost title in the present application in view of the order dated 3/12/2025, passed in IA Civil 3659 of 2020.
Deeply obliged.
And in the appeal also,
Lordship in all the applicants,
and in the,
including the appeal. Yeah.
all applications and the appeal. Huh? Item? 54. 250. Any objection, Mr. Kane?
Yes, my lord, there are 258 days delay, number one. And number two, my lord, kindly see, they were sitting over the judgment only because the time came that my nomination to the IAS became an issue, my lord, then they filed the appeal. Kindly see the conduct, my lord. And my lord, merely because they are government, they are not entitled to any special privilege. Because Supreme Court has, there was some point of time, Supreme Court took a very liberal view in these matters. Now, my lord, anything beyond 100 days, unless they can explain, this will not be normally be, my lord, condoned. And in on merits also, what is the case, my lord? Because there was an acquittal in the criminal case, therefore the Honorable Learned Single Judge says that enough is enough now. You bring the whole thing into, some conclusion. Now, my lord, what they have explained, they have not been able to explain anything.
Okay, we'll pass. You'll have filed your.
We have filed our objection.
Well, the acquittal is on benefit of doubt.
Yes.
Well, the law is well settled. Well, in fact, the law.
Not an honorable acquittal.
It is not an honorable acquittal. Page number 95 in the appeal memo. The order is there.
Yes.
Page number 95, Lord. This is the order passed in the criminal case.
Page 95 of the appeal. Anyway, we'll take up the written objection.
Lordship.
So what is the ground for delay?
Lord, we have explained the delay in the IA, my lord. Lord, kindly come to page number 3, my lord. Lord, the Learned Single Judge has passed the order on 29/10/2024. That order, my lord, Lordship has, the Honorable Court has directed to conclude the departmental proceeding. And my lord, the department after the order, my lord, para number 1, my lord, page number 3. The Learned Single Judge by impugned judgment and order dated 29/10/24 passed in WPC number so and so has disposed of the writ petition directing the respondents to conclude the departmental proceeding pending within a period of 1 month from the date of receipt of the certified copy. And the certified copy we have received on 4/11/24. After receipt of the copy, my lord, para number 2, the department has processed the file of the departmental proceeding pertaining to the opposite party number so and so and returned back that was returned from the office of the senior government advocate. The records were with us. We have returned the file and accordingly they have processed. But in the meantime, the 1 month time is over. Therefore, para number 3, in view of expiration of the time frame for conclusion of the departmental proceeding, as per direction of the Honorable Court, the applicants in the month of December 24 had preferred an interlocutory application being registered as IA number 4343844 of 2024, seeking extension of 3 months time to conclude the departmental proceeding. Then in that IA, my lord, the Honorable Court by order dated 9/1/2025 in the aforesaid interlocutory application rejected the prayer of the applicants for further extension of time for conclusion of the departmental proceeding and directed the applicants to conclude the departmental proceeding strictly within 1 month. But then the matter was processed. Paragraph number 4, we have said the departmental proceeding was resumed by an order dated 6/2/2025. By order dated 6/2/2025, new inquiry officer was appointed to complete the departmental proceeding. In the meantime, the opposite party has preferred a writ petition being registered, being WPC number 1076 of 25 against the order of appointing new inquiry officer. And the Honorable Court by order dated 6/3/25 state the disciplinary inquiry initiated against the petitioner. This we have annexed, annexure 2. So in that circumstances, the department has approached the council. We have sought for the relevant records and all. But the department was directed to conclude the departmental proceeding, and the department is under an impression that they have to conclude it as per the rules. They have appointed the inquiry officer, but the paragraph number 30, 33, and 34 in the impugned judgment, those are there, in view of that, the Honorable Court has against passed the order at page number 14, my lord, page 14. There is a stay to the departmental proceeding. Thirty-three has been quoted. Page 15, it starts, the order starts at page 15 in the IA filed by us, my lord. The order is 6/3/2025. After the inquiry officer was appointed, this was filed, my lord. The writ petition is directed against the order dated 6/2/2025 passed by the Secretary to the Government of Assam Personnel Department appointing a new inquiry officer to inquire into the charges brought against the writ petitioner. According to Mr. Chaudhary, in view of the specific direction contained in the judgment and order dated 29/10/24 passed by the learned single judge in WPC number 1053 of 24, there was no scope for the authorities to appoint a new inquiry officer and continue with the departmental proceeding. Mr. Chaudhary has also invited the attention of this court to the order dated 9/1/25 passed in IA number 3844 of 2024 arising out of WPC number 1053 of 2024 to submit that a request made by the state, the learned single judge had granted extension of time only for only 1 month to conclude the departmental proceeding, failing which adverse consequences were to follow. Under the circumstances, Mr. So-and-so submits the impugned order dated 6/2/2025 is wholly arbitrary and illegal. By referring and relying upon the decision of the Honorable Supreme Court rendered in the case of GM Tank, Mr. So-and-so submits the law is firmly settled that after acquittal of the delinquent in respect of the charges brought in a criminal proceeding, founded on the same set of facts, documents, and witnesses, there is no scope to conduct the departmental proceeding on the same set of charge. As such, a prayer has been made to set aside the impugned order dated 6/2/2025. Taking note of the grievances expressed in the writ petition and submission advanced by the petitioner's counsel, this court, by order dated 28/2/25, had granted time to the learned government advocate to obtain instruction and address the issue raised by the petitioner's counsel. Today, when the matter is called up, Mr. So-and-so submits that although there is a direction by the learned single judge to conclude the departmental proceeding within specified time frame, which period was subsequently extended for a period of 1 month with effect from 9/1/2025, yet it was open for the department to complete the process by holding for further inquiry. Mr. So-and-so, however, submits that the department is contemplating to prefer an appeal against the judgment and order dated 29/10/2024. Therefore, there is no necessity for the court to interfere with the impugned order dated 6/2/2025 at this stage. After careful examination of the materials on record, I find that the writ petitioner, wherein while he was serving as Chief Executive Officer, Dorong Jilla Parishad, was arrested by Vigilance and Anti-Corruption Cell, Assam, in connection with ACB case number so-and-so.
Yes.
Well, para 33 of the impugned judgment, which we have selected, that has been quoted, kindly see, page number 18. This is the para 33 of that judgment. The learned single judge has recorded that as noted above, in the present case, the departmental proceeding and the criminal case are based on identical and similar set of facts, and the charge in the departmental case and the charge before the criminal case against the petitioner are also one and the same. The listed witnesses in the departmental case were examined in the criminal case, and the criminal court, upon examination of such witnesses, has concluded that prosecution has failed to establish that the petitioner accused has demanded illegal gratification from the informant. That being so, in the considered opinion of this court, further continuation of the departmental proceeding against the petitioner is wholly unfair and unjust. And thereafter, the Honorable Court has directed, by the judgment and order dated 29/10/2024, 1 month's time was granted to the departmental authorities to conclude the departmental proceeding. Instead of doing so, the department had moved an application, being IA number 3844 of 2024, seeking 3 months extension of time to comply with the order. By the order dated 9/1/24, passed in IA number so-and-so, the learned single judge.
Yes. So that's all?
That's all. Look, under that circumstances, we had no option because the departmental inquiry is to be completed by as per rule. And the GM Tank decision, the learned single judge has followed. In the GM Tank, it was a case of honorable acquittal. In fact, there was no evidence in that case. But at a similarly, the position is also clear that where the acquittal is on benefit of doubt, the departmental proceeding as such on acquittal doesn't come to an end.
The basic case is that there is no bar for coming to a different decision
Lodging.
when the criminal case ends by giving the accused benefit of.
Benefit of doubt. And my lord, when the honorable, the learned single judge has directed us to conclude the departmental proceeding, my lord, we have to conclude the departmental proceeding as per rule by appointing the inquiry officer. The manner in which the order has been passed, the direction has been given, my lord. If lordship for a moment kindly takes out the impugned judgment, my lord. In fact, the petitioner, the respondent petitioner herein was acquitted on benefit of doubt, was not even considered in the order. Only acquittal has been considered, but it was whether it is an honorable acquittal or on benefit of doubt, it was not considered at all.
Yes.
Yes. My lord, my lord, let us be very clear about few things, my lord. Yes, there is no bar for a simultaneous proceedings, that is criminal and department. There's absolutely no bar. But there are certain situations where the Supreme Court has said, my lord, that normally the departmental proceedings should not proceed. The situation is when the charges are same set of witnesses are sought to be relied upon. That is the only exception which has been carved out. Now, my lord, that is one aspect. The other aspect is, yes, it is also a correct proposition of law. If the acquittal is on benefit of doubt, because there is a judgment of 1984, then it may still be open for the disciplinary authority to proceed departmentally. But is it the case same here? It is not a case either of the department or of me that because there was an acquittal benefit of doubt, therefore the disciplinary authority is still within its competence to continue with the DP. No. Here the case is, my lord, since it is based on the same set of facts and charges, therefore since there was an acquittal, it's not a question of honorable acquittal. It's a question of since there is a case of acquittal in the criminal case, therefore it would be Supreme Court has used the language unjust and onerous to continue with a departmental proceeding. But the GM Tang judgment which we relied upon and which has been relied upon by the Supreme Court, the facts are like this, Miller. There in the disciplinary proceeding, he was Miller punished. Meanwhile, he got an acquittal in the criminal case. There Supreme Court said that no, since it was based on the same set of facts, same set witnesses, therefore he must get the benefit. Now, where is the question of benefit of doubt and all? Okay, what we are doing from March till September? Well, they have to explain because, my lord, the Supreme Court says that whenever you want to tinker with somebody's accrued right, that you must show that you are vigilant. If you are not vigilant, then you are not entitled to invoke the jurisdiction of the court. Here in this case, my lord, our pure and simple case is, kindly come to this, my lord, petition. Why the learned single judge allowed our writ petition? They have quoted the two paragraphs. My lord, why they filed that IA? For their wrong understanding, a litigant cannot suffer. Please come to my lord, para 11, page 11. In the original writ petition, when the single judge allowed our writ petition, two paragraphs, 33 and 34. That will make the position clear. As noted above, in the present case, the departmental proceeding and criminal case are based on identical and similar set of facts. And the charge in the departmental case and charge before the criminal court against the petitioner are also one and the same. The listed witnesses in the departmental cases were examined in the criminal case, and criminal court, upon examination of witnesses, has concluded that prosecution has failed to establish that the petitioner accused had demanded illegal gratification from the informant. That being so, in the considered opinion of this court, further continuation of the departmental proceeding against the petitioner is wholly unfair and unjustified. Accordingly, this court deems appropriate to dispose of the writ petition in the interest of justice by directing the respondent authorities to conclude the departmental proceeding which is begun against the petitioner in accordance with law by keeping in mind the observations made herein above. That means observation made in para 33. My lord, if the government of Assam understood this paragraph 33 and 34 as enabling them to appoint another inquiry officer to conclude the departmental proceeding, my lord, that is absolutely wrong.
He retired. That's what they,
Yeah, my lord.
he retired.
No, my lord, that is not the issue. No, Lordship will kindly appreciate the question. It's not a question of whether an inquiry officer retires. That is not the issue. Issue is can you appoint a second inquiry officer? That is the issue. And I have brought all the judgments where Supreme Court says no. What is permissible under service jurisprudence is a further inquiry, not a new inquiry, not a new appointment of a new inquiry officer. Yes, if the inquiry officer is incapacitated, huh? Lord, when in para 34, a direction was issued to conclude the departmental proceeding, it was not a direction issued to them to appoint a new inquiry officer and conclude the proceeding. Rather, the direction was consistent with the observation made in para 33. That means this proceeding cannot continue any further because it is grounded on the same facts. In other words, the learned single judge, while exercising power of judicial review, my lord, do not exercise appellate power. Therefore, instead of the learned single judge itself, my lord, interfering with the proceeding, has remanded the matter to the authority. Now you conclude the proceeding. The direction was not an opportunity given to them to appoint a second, third, fourth inquiry officer and to conclude it. So it has to be understood in the perspective, my lord. What they are a misunderstanding, the law cannot change. They say, we have been given an opportunity to conclude the proceeding, therefore we can appoint another inquiry officer. No. The learned single judge said, since these were grounded on the same set of facts and there is an acquittal in the criminal case, therefore this proceeding should be brought to its logical end. And to understand that, because in the meantime the issue cropped up of nomination of my case to the Indian Administrative Service, therefore, my lord, they have filed an appeal. Can we see their conduct, my lord, end of the day? It is not a case of because it is an honorable acquittal, therefore disciplinary proceeding can again go ahead. That is not the case. It was never their case. So therefore, my lord, end of the day, a litigant, my lord, he is suffering. Therefore, justice should be done to him, my lord. And my lord, 258 days is not a very a period which can be, yes, less than 100 days, normally when we don't object also. And more so, my lord, in an adversarial system of litigation, every litigant has his right to, my lord, take protection of the law, please available in law. After that Chief Postmaster General's judgment in early 2000, my lord, now I think the Supreme Court's view has changed. Earlier, my lord, Supreme Court was very liberal when it comes to condonation of delay at the instance of the government, because government was considered to be an impersonal machinery. There are typical ways of movement of file. So naturally in the process some time was taken. But that view had changed over the last 2 decades. And now the view is anything above 100 days, you must explain. Therefore, in that view of the matter, Lordship will take a call on the condonation petition which has been filed by the state. And my lord, the judgment which we are relying, which have already indicated in the
Only one thing, I'd like to indicate, during pendency of the writ petition, the records were called for and that order.
With the Lordship's kind permission, I have to make a mention in a matter.
The departmental proceeding record were called for in the, while the repetition was pending, records were with us and the proceeding could not, it could not proceed. That interim order was, that order we have annexed at page number 195. In the writ appeal, my lord, we have annexed. So the records were with the, one of the records were here, so departmental proceeding could not proceed. And secondly, my lordship may kindly consider the 195 in the writ appeal, in the appeal memo. The records were called for and the records were directed to the CAM. So all along the departmental proceeding was in fact challenged the writ petition. I have annexed the writ petition copy.
Yeah, that's the order.
Lot.
What was called for 12/9/2023. Is it?
Departmental inquiry, including inquiry report submitted in the departmental proceeding initiated against so and so would be necessary. Those were called and those were with in the.
Okay,
Those are
so 12/9/24.
lot. And it
12/9/24.
and the very challenge
Got called for.
and the very challenge in the writ petition was against the departmental inquiry. And one of the decision of GM Tank has been relied by the learned single judge while passing the order. And it is specifically in GM Tank.
When was your appeal filed? This appeal filed?
We could file the appeal on 14/8. 14th of August.
14 August 2020.
25. So if lordship kindly.
So this record was called for on 12/9. Did you produce the record?
Yes.
When? On the next date?
Records were there, my lord. In fact, while passing the judgment, my lord. While passing the judgment, records were with us. At page 171, the judgment starts. In the appeal memo.
No, the records were called in WPC 1076.
No,
17076.
1053. Page 195.
195 is with regard to 1053.
1053.
Okay.
We are on 1053. 1076 is the next case.
The second on the.
105. And then at page 171.
171.
73.
Look.
That was our 2910.
If lordship kindly comes to page 173, that is the issue. We have said that the Honorable Apex Court decision in State Bank of India versus P. Jadenga, the departmental proceeding, although acquittal, it is permissible. That is not the case. And ultimately in para 28, GM Tank has been considered. In GM Tank, my lord, I respectfully submit, my lord. It is the issue of honorable acquittal. In fact, the decisions were discussed in para 16 onwards. The issues are there, and those were considered. My lord.
Heard Mr. Srinath, Learned Counsel for the applicant appellant.
Lord.
Also heard Mr. K. Chaudhary, Learned Senior Counsel for the respondent.
One, your lordship. Opposite party one and respondent number one.
Assisted by.
TJ Das, your lordship.
So we give the order, we give them the main. The section of the. of the pass that we did the order is out.
Lord.
Hearing computer as. Have we finished? Is there any more?
Final 15.
Lordship, I'll pay for adjournment if possible, Lordship.
Sorry. Matter is pending in Supreme Court.
Yes, your lordship.
Then why should we keep it pending here? You can file afresh again after the Supreme Court order if the order does not cover you. Heard, Mr.
S. Diffuser.
Uh,
S. Diffuser, Your
S. Diffuser,
on behalf of D. Chaudhary.
appearing on behalf of Mr. T. Chaudhary. Also heard Mr. T. Biswas,
On behalf of the railway.
on behalf of the railways, and Mr. R. K. D. Chaudhary.
Well.
The petitioner's
Exactly.
case is that the respondents have failed to protect and promote the cultural, social, and linguistic identity of the Assamese people, or to safeguard the economic development of the state, for which the Assam Accord has to be implemented in right earnest. The petitioner is also concerned with the insignificant number of deportation and the illegal and the continued stay of illegal migrants in the state of Assam. The petitioner's prayer is thus is the petitioner's prayer is for implementation of clause 5.1, 5.2, 5.4 and 5.5 of the Assam. As Assam. I think he cannot be declared. This that's the CA, no? That's CA, yeah, the CA. The prayer number 3 of the petition for declaring the proposed bill for regularization of the foreigners of Hindu religion who have migrated into India till 2000. And to be as illegal, null and void, has apparently become infructuous in view of the coming into force of the, what is that act? CAA. Citizenship Amendment Act of 2020. Yes, 19. Not 20, but 2019. Next step. On considering the fact that the Supreme Court of India by order dated 17/10/2024. In WPC 274/2009. And other analogous matters that upheld the validity of section 6A of the Citizenship Act 1955. And keeping in view the fact that the issue raised in this writ petition is already pending before the Supreme Court. comma. We are of the view that the petition, the present PI should not be kept pending in this court any longer. Accordingly, we close the PI, awaiting the decision of the Supreme Court. That's it. Right, yeah. Okay, anyway, good continue. Accordingly, the trial stands closed. With liberty being given to the petition to. No, that's, I was awaiting the decision of the Honorable. Congratulations.
May I please? Lord, during the pendency of this case, my lord, we have filed one miscase. Miscase, my lord, this is they have, my lord, issued another advertisement during the pendency of the case, and in the main case, though there was direction from this honorable court to file the affidavit that had not been filed.
No, in which I, this,
I-
3860, what is the?
Three
let
eight
us
three
see.
zero. This is, my lord, we have put to challenge the subsequent during the pendency of this case that they have issued one advertisement, my lord, whereby the state.
28/10/25.
Yes, Lordship. Whereby, my lord, they have desired to regularize the teachers of serving in the contextual basis under SSA, and they wanted to bring them under the elementary education department, my lord. We have no objection with regard to that, but our case is, my lord, that our past service benefit will be, my lord, will have to be given up. That we have put to challenge here.
No, what do you want? This advertisement dated 28/10/25.
Yes.
Which page?
Page 30, my lord.
30.
Yes. So this advertisement, this is not a new recruitment. They are not inviting any outsiders. Those who are.
You see, this advertisement has been issued.
Yes.
In exercise of the powers under the Assam Elementary Education Provincialization Amendment Rules 2025.
Yes, Lordship.
Shows this rule.
That rule has not been published as on date. We have searched everywhere. The rule has not been published. But
Then
we have put to challenge the earlier main rule, my lord, 2024 in the main writ petition. That is under challenge. And instead of publishing that rule, my lord, they have issued this advertisement, my lord.
So this advertisement, whether this advertisement has been issued.
Yes.
On the basis of the 2025 rule.
They have stated. But
Correct.
it is not.
Have this 2025 rules come into force?
That is the thing.
That, today, my lord, that instruction I don't have. He
That-
is saying that, he is saying that, my lord, it has been not in public. But without publication of the rule, my lord, I don't think so they will.
Yeah, but he's brought out an issue. That is the long and short of it. If it is issued as per rules, then he's got nothing. He's got nothing to say. But if it is issued without the rules being enforced, then this advertisement will have to go. Simple as that.
My lord, pick the next week, my lord.
Let us see the rule. Where is it? Is it here?
It is not, my lord, rule, the main rule is not here.
In earlier rule, the qualification experience period was 5 years.
We are not on that.
And
We are on this advertisement,
yes, sir.
which has been made on the basis of the 2025
That has
rule.
not been enacted with the IM, my lord.
That is not published yet, my lord. We have enacted
He says
11.
that it has not been published.
At page
Anyway.
yes, page 29, your lordship will find, we have given the government press website, my lord, relevant page of publication. Your lordship will find the dates 7/10/2025 is notification published, and 29/10/2025 notification published. In between 28, my lord, this is not published. We have personally sent the candidates, my lord, in the office. They have stated that
Okay, right.
no publication.
In the IHT, heard Mr. B. Purkayastha, learned counsel for the applicant who submits that the advertisement for special recruitment drive dated 28/10/25, 8:30, issued by the Director Elementary Education has been made on the basis of the Assam Elementary Education bracket provincialization bracket close, then another bracket amendment rules, 2025, which has not come into force, hasn't been. Mr. N.J. Katade, learned counsel for the elementary education department shall obtain instructions with regard to the above.
But come on the next week, my lord, on Wednesday.
When can you give? Just you can ask them now also.
Next week, any date, my lord.
On 9th, my lord.
Problem is. This is the matter on 9th.
My lord, may I pray for a status quo, my lord, as on date, my lord? Otherwise, my lord,
When is the last date? Okay.
last date, my lord, today, they are going on extending, my lord, the days that they have extended time to time.
30/11/2025. 30/11/2025.
You also come late.
We have filed the miscase, my lord, before that, and as the main case is fixed today, my lord, the honorable court has permitted us to move it today. As on date, nothing has happened.
So if nothing has.
You filed this on 26th November.
Yes, that's true.
List the matter on 9th.
I'm appearing in item number 36, Lordship, we have filed an affidavit in reply, Your Lordship, that may be brought on record, Your Lordship. Maybe take together on the need state, Your Lordship.
Okay, in item, in this state,
DJ Das, Your Lord.
DJ Das.
In item 36.
Appearing for
the petitions.
For the petition. Your name is not here.
Lordship, I am appearing on behalf of Mr. Kane Chaudhary, Your Lordship.
You are appearing on behalf of the senior.
Yes, Lord.
Appearing on behalf of.
Not on
the
behalf
K.
of.
Chaudhary,
this
counsel
is-
for the. Huh?
Lordship, his name may be recorded, Your Lordship.
Mr. N. Gautam, appearing on behalf of the petitioners in WPT 5207/2024. Submit that affidavit in reply has been filed. Registry to place the same on the.
In our main case, my lord, there was a direction to file the affidavit, my lord, and that has not been filed, my lord. That's why we.
We'll see on 9th.
Right.
Please, Lordship.
It's because they don't.
May I please, your lordship?
Huh?
Today I'm little bit unwell.
Today? Oh, you're not,
Today I'm little bit unwell, Lordship.
yeah, unwell.
Can it be taken up some other date? But otherwise, my
My
Lord.
lord, my co-appellant, I'm on bail. I don't have any problem. He is stuck because
Now that latest judgment is there, parity.
Is okay, Lordship.
You cannot get bail on the grounds of parity.
Yes, Lord.
Huh? Came out when? This month.
Lordship, my humble submission is that in this case, the learned is has nothing to do much hard work, which we have to done. So she may comfortably sit. We can.
No, I don't know whether that is a good submission. He thinks he's unwell.
Lordship, then the 10th of this month, Lordship.
17, my lord.
Okay, 7.
17.
Huh? On the prayer made on behalf, Miss
SH board.
S.H. Bora, additional PP submits that she is feeling unwell. Accordingly, on her prayer, list the matter on 17th.
Ideal.
Something or the other always happens.